This episode is brought to you by Shopify. Whether you're selling a little or a lot, Shopify helps you do your thing, however you cha-ching. From the launch your online shop stage, all the way to the we just hit 1 million orders stage. No matter what stage you're in, Shopify's there to help you grow. Sign up for a $1 per month trial period at shopify.com/special offer, all lowercase. That's shopify.com/special offer.
Five Below means hot stuff, cool prices. Get the trends in your feed for way less. Candy, beauty, tech, room decor, and more. Plus, extreme value finds in our 5 Beyond shop. Yup, you could say we're kind of a big deal. Shop in stores and fivebelow.com.
Hi, and welcome back to Amicus. This is Slate's podcast about the courts and the law and the Supreme Court and democracy. I'm Dahlia Lithwick. That's what I cover here at Slate. And on Friday, the High Court handed down 4 cases and announced that the last few decisions of the term are coming Monday, July 1st, including the long-awaited question of whether former President Donald Trump is immune from criminal prosecution, and the term will wrap after that. Friday's cases included a major decision about whether cities can criminalize sleeping in parks, aka homelessness. Answer, yes, indeed, they can. Also, a decision to overturn the longstanding Chevron deference, dealing a real body blow to the administrative state. And finally, a decision in Fischer to narrow the federal obstruction statute that lies at the heart of hundreds of prosecutions connected to the January 6th attack on the Capitol. All in all, a really big power grab day for the Supreme Court, and an ominous sign that presidential candidates may win debates or lose debates, and that these performative network moments is not what we should focus on, because the real revolution is happening across the street. Joining us today to discuss the penultimate day of the SCOTUS 2023 term is Professor Pam Karlan, co-director of Stanford Law School's Supreme Court Litigation Clinic. Pam has served, among many other places, as assistant counsel and cooperating attorney for the NAACP Legal Defense Fund, and twice as a deputy assistant attorney general in the Civil Rights Division of the Department of Justice. And Pam and I are joined, of course, by the indispensable Mark Joseph Stern here at Slate to help unpack what has just happened and what is to come. Welcome, Pam.
Thank you for having me.
Welcome, Mark.
Hi, Dahlia.
This is a subduedest dude. This is a day. So listen, go ahead, Mark.
I'm just so sad, Dahlia, that the court is doing all this in a way that makes it maximally difficult for the public to understand, and that it's doing so stretching into July, holding the immunity decision in a way that seems designed to mute its impact. I just feel like the court is up to so much bad stuff right now, and we try to cover it like it's like a not totally corrupted institution. And I'm just telling you now, I'm going to struggle to strike that pose in today's episode. That's all I'm saying.
Pam, do you have any sad feelings that you would like to express to go along?
Therapist, Dahlia.
To go. Caller, how can I help?
It is amazing what the court wants to criminalize and what it doesn't. That's one of the striking things about the court right now is they want to allow the criminalization of homelessness while making it harder, for example, earlier in the week to criminalize somebody getting $13,000 as a public official for services rendered. And by narrowing the scope of the federal obstruction statute, it's bad in both directions.
So our last show, which came out all of 36 hours ago, came out after Jarkissi and came out after the EPA was hobbled. And this sort of stood as a bedside vigil for the administrative state. But holy cow, the decision in the pair of Chevron cases takes this to a new level. Now we're not at bedside vigil. Now we're at requiem with full black veils and, Latin humming.
I've covered my mirrors and I'm rending my garments, Dahlia. I don't know about you.
Is
there any smoked fish on the horizon?
Yes. There is a table.
It's ironic that they
bagels.
did this in a case involving fish.
It's so interesting that I go right to like Catholic Mass and you all properly go straight to the sable and the lox and the chive cream cheese. So listen, this is hard to explain, and I want to just be really clear. Pam wasn't here. We talked to Lisa Heinzerling at Georgetown, but it's so hard to take the abstraction of what happened in Jharkhasi, what happened in the EPA case, the Good Neighbor case, and put meat on the bone so that folks understand. But Mark, can you just start by telling us what Loper Bright, aka the Chevron case, was about, and how what was like a pokey little dispute over like fishing monitors on boats turns into today's missile that strikes at the very heart of the administrative state?
Yeah, I mean, this case should not even exist because the controversy that's ostensibly in dispute is over. The Trump administration had imposed this rule that required the fishing industry to help cover some of the costs of the federal compliance monitors who sometimes go on the fishing vessels. The Biden administration came in and repealed that rule and refunded all of the money back to the fishing industry. So there's no live case here, but the Supreme Court spotted this as a great vehicle to overturn Chevron deference, which we'll talk about in full very soon. And so the court grabbed this case, Loper Bright, and a companion case that's been folded in called Relentless, in order to, I think, finally once and for all overturn Chevron deference, amass a bunch more power within the federal judiciary, and strip a lot of power from Congress and the executive branch. And it did so ostensibly on behalf of these fishermen who say, we don't want to pay for compliance monitors. Federal statute doesn't allow, the government to make us pay for this, even though they've already been made whole. They've got all their money back and there's nothing for the court to decide. It decides nonetheless.
What the Supreme Court held in Loper Bright was that the Chevron doctrine, which essentially said that when a statute is unclear, federal courts should defer to a reasonable interpretation by administrative agencies, is no more. That courts do not need to defer at all to agencies. They can simply decide from the get-go what a statute means, regardless of what the agency thinks.
And Pam, let me ask you a version of the same question, which is, how is it that this is a, years-long project that, by the way, the biggest fan of Chevron, as I understood it, was Justice Scalia. But here we are at the, I think, terminus of a years-long project to essentially transfer power from the ABC agencies over to the court. And it is so invisible to so many people who get very upset about gun cases. They get very upset about the immunity case. They're going to get very, very upset about whatever it is that happened in the pair of abortion cases this year. But in some sense, this subsumes all of it because this fundamentally changes the way government governs. Can you give your best shot at explaining what happens after today if you are a federal agency just trying to do your work with experts and science?
Using that phrase, the best shot, actually allows us to give an example that comes from this year at the court already, which was, remember earlier this term, the court had in front of it a case about whether bump stocks could be banned as a form of machine gun. There's a federal law that says machine gun, individuals can't own machine guns. And the question is whether a bump stock is a machine gun or not. The ATF, which is an agency of the federal government, is part of the Treasury Department or maybe Homeland Security now, but they have expertise in firearms. That's the F of ATF. And they said, we've looked at this. Actually, during the Trump administration, we've looked at this, and bump stocks really allow guns to function like machine guns. So we're going to say the federal statute that bars people from owning machine guns bars owning bump stocks. And the Supreme Court came in, and I guess one of the two of you must have been in the courtroom for the argument in this. The justices are all going bang, bang with their fingers, trying to figure out how these things work. And they decide, well, we can just decide this for ourselves, whether a bump stock is a machine gun or not. We can decide for ourselves what these statutes mean because we're experts at everything, and the agencies are not. And what this means is that when you have a statute where the question is, how ought we to interpret these words which are not pellucidly clear? Do we rely on experts to tell us, experts about the subject matter to tell us, at least in the first instance? Because all Chevron says is, if the agency has a reasonable interpretation, you ought to go with the experts on a reasonable interpretation. It doesn't say that the agency can do whatever it wants. But the Supreme Court really has decided that they know more than everybody else about everything. And so they don't really feel any need to listen to the agency beyond giving it a chance to say what it thinks in court. And then the court will decide. Now, this by itself is pretty aggressive. But when you add to this what the court has done with another doctrine that it invented, so at the same time it's getting rid of a 40-year-old doctrine, it's inventing a new one. And the new one it invented was this thing called the major questions doctrine, which is, if it's a really important thing, we're going to assume the agency can't do it unless Congress explicitly said the agency can. That if it just seems within the bounds of the agency, that's not good enough. What they've really done is they've kind of kneecapped both knees of federal agencies and meant that, they've now embarked on this really deep deregulatory process, deregulating control over the environment, deregulating control over health and safety, deregulating control over medical care, deregulating control over harmful substances, unless they themselves think the thing should be regulated.
In keeping with using the word shot recklessly today, I was going to just take one gratuitous pot shot, which is that the same court that, at least in the words of Justice Kagan in her dissent in Loper Bright, who laments the fact that the majority has, quote, turned itself into the country's administrative czar, right? Like, she is horrified at the move you both have just described. I just want to point out, kind of slightly meanly, that this is a court that can neither manage its schedule nor uploading cases on the right day, nor the correct definition of nitrous oxide. I mean, this is a court that is giving itself the power to decide all the things and can't even do its own job.
Yeah, that last example is so well timed, right? On Thursday, the Supreme Court blocked this EPA rule, and Neil Gorsuch wrote this opinion where he presented himself as the world's foremost expert on smog emissions. And he repeatedly confused nitrous oxide, which is laughing gas, with nitrogen oxide, which is the emission that causes smog that was at the heart of the case. This guy can't even tell the difference between laughing gas and smog pollution. He wants to, and now has, presented himself and crowned himself as sort of the king of the entire regulatory structure. Chevron deference was a simple proposition that when Congress enacts laws, it can't write them perfectly. It can't foresee every problem that the law will have to address, and it has to task certain decisions to federal agencies. Congress is not going to tell the EPA, here's the precise formula for how to limit mercury. It's going to say, you need to limit mercury, figure out how much you need to limit to protect human health. Chevron says when the law is ambiguous, when there are gaps, when there's confusion, federal courts need to defer to the agency's reasonable interpretation. And again, I just think that key word here, reasonable, gets lost in a lot of this conversation because we're talking about decisions that are rooted in the law that often there's no one correct answer. And that's why sometimes, and Justice Brett Kavanaugh was aghast about this during oral arguments, but this is just sort of the way it works. One administration will say the law means one thing, another will come in and interpret it differently. That's okay. Reasonable minds can disagree. There will always be disagreements. There will always be ambiguities. The big question is who decides what the answer is. And what the Supreme Court declared on Friday is we decide. We overrule the experts. We, the unelected, unaccountable judges, are the ones who will decree what this law means. And so I think it doesn't just limit the agencies. It limits Congress's ability to write legislation in a way that Congress thinks is effective and helpful. to write broadly worded grants of power to these agencies. And so, we talk about how this is shifting power from the presidency and the executive branch. Absolutely it is. We talk about how it's creating less accountability. Totally true. Because if we don't like an agency interpretation, then we can vote out the president. But I can't vote out Neil Gorsuch for not knowing anything about nitrous oxide or nitrogen oxide. But it also is telling Congress, you don't get to write laws the way that you prefer to write laws. You have to write them more narrowly and more specifically in a way that will make it harder for these laws to endure through the ages and be a tool for the actual experts and political appointees to apply them to evolving problems on the ground.
And maybe just one last example of the same problem also from this week, but it doesn't immunize you from not knowing anything about a thing to say, I don't know anything about a thing before you opine on it. And I just want to flag Justice Samuel Alito in the EMTALA opinion being like, I'm not a doctor, but, and then do emergency medicine from the bench, except you do. I want to just follow on to one thing you both have said, because it seems to me I read Kagan dissenting in the Chevron case, not simply saying that this is a massive power grab, never before anticipated and shocking in its magnitude. I also read this as an elegy for stare decisis again. This feels like the Dobbs dissent again. This is saying to the court, not only are you doing something that is unbounded in the damage it can do, you are also reversing precedent willy-nilly because you feel like it. Either of you have some thoughts on the ways in which sometimes I feel like when Justice Kagan is angriest, the thing she's angriest about is how recklessly the court does the thing that it's doing that is so damaging.
I actually don't think this is reckless. I think this is purposeful. I don't think this is that they don't understand what they're overturning. And then, of course, in Justice Gorsuch's opinion, he kind of says, well, we'd already gotten rid of Chevron and it was dead man walking. So I don't know what everybody's so upset about. And the answer is that most cases don't go to the Supreme Court. Most cases are decided by district courts or courts of appeals, and they were still applying Chevron. They were taking it seriously, and they were giving deference to reasonable interpretations by agencies rather than saying, well, I recognize, and this goes back to what Mark was saying, I recognize reasonable people could differ on this, but I just don't like your position, so I'm going to impose my own. That's what's so troubling about this, is these are all cases where the agency is offering a reasonable definition.
Can I just add one point that I think is so interesting in Justice Kagan's dissent, which is she's really candid and injects some real politique into this. And she calls out the majority for engaging in a years-long strategy to undermine Chevron, right? She says, it's true that this court has not applied Chevron since 2016, but that is because it has been preparing to overrule Chevron since around that time. That kind of self-help on the way to reversing precedent has become almost routine at this court. Stop applying a decision where one should, throw some gratuitous criticisms into a couple of opinions, issue a few separate writings like concurrences or dissents, questioning a decision's premises, give the whole process a few years, and voila, you have a justification for overruling the decision. She cites Janus, overruling Abood. She cites Kennedy versus Bremerton, overruling Lemon. She cites Shelby County. It feels like she's sort of pulling back the curtain to invite all of us to see what her colleagues are up to. And in the process, not pretending as though this is all purely organic law that simply develops through the collective genius of 9 justices. This is a fundamentally political endeavor to plant the seeds of undermining a decision so that a few years down the road, you can make it look like it's actually rooted in precedent to overturn precedent when that is all smoke and mirrors.
And can I just add something to this, which is, you mentioned this earlier, Dahlia, that it used to be Justice Scalia was the major proponent of Chevron deference. And what you're now seeing is because of a change in the politics and the view that maybe they won't always hold the executive branch, but they're going to hold the judiciary for a good long time, they don't want to defer to the executive branch anymore because the executive branch may have a Democratic president. The courts, at least the Supreme Court, is going to be a Republican court for quite a while, and they can dismantle a lot of stuff at the court that they wouldn't be able to dismantle through the political process.
Let's pause to hear from some of our great sponsors. From Picasso to Cleopatra, the podcast Legacy looks at the lives of some of the most famous people ever to have lived and asks the question, do they have the reputation they deserve? This season, they take a look at J. Edgar Hoover. Hoover was director of the FBI for half a century. An immensely powerful political figure, he was said to know everything about everyone. And he had the ear of 8 presidents, and they were all terrified of him. When asked why he didn't fire Hoover, JFK famously replied, quote, "You don't fire God." From chasing gangsters to pursuing communists to relentlessly persecuting Dr. Martin Luther King and other civil rights activists, Hoover's dirty tricks and tactics have been endlessly echoed in the years since his death. And his political playbook still shapes American politics today. Follow Legacy now wherever you listen to podcasts. You can discover more to the story with Wondery's other top history podcasts, including American Scandal, Black History for Real, and even The Royals.
It's hard to imagine a world where we leave future generations with fewer rights and freedoms. The Supreme Court has stolen the constitutional right to control our bodies. Now politicians in nearly every state have introduced bills that would block people from getting the essential sexual and reproductive care they need, including abortion. Planned Parenthood believes everyone deserves access to care. It's a human right. We won't give up and we won't back down. Help ensure the next generation can decide their own futures. Donate to Planned Parenthood. Visit plannedparenthood.org/future.
I want to turn to Grants Pass just for a minute because it's going to get lost in the blizzard of what came Friday and what's coming Monday. And yet it seems like an incredibly important case for some of the reasons that Pam started with up top. You know who won big again this term is the billionaires and the millionaires and the oligarchs and the people that the SEC are trying to bring enforcement actions again. You know who lost big time was people who are trying to sleep in parks in Oregon. Mark, can you just walk us through how Grants Pass comes to be before the court? And can you give us a sense of what happened Friday?
Yeah, this is just a horrible decision for homeless people, for disabled people, for individuals who do not have a ton of money and maybe aren't in a position to solicit a $13,000 check in reward for their service as mayor of a town in Indiana, to call back a recent case. The Ninth Circuit had said that it is cruel and unusual under the Eighth Amendment to punish an individual for sleeping outside when they have nowhere else to go, when there is no available shelter, because that is punishing them for the status of being homeless rather than for any particular kind of conduct. There is a lot of misinformation that blames the West's homelessness crisis on the Ninth Circuit's decisions here. I think that is just obviously not true. It is a deep, complex crisis that has only been kind of managed around the edges by a handful of Ninth Circuit decisions that say in some discrete cases, hey, this town launched a crusade to target homeless people for existing as homeless people. The Eighth Amendment doesn't allow that. And that's what happened in Grants Pass. You know, the dissent here by Justice Sotomayor shows all this evidence that the policymakers in Grants Pass decided there are too many homeless people here. How can we target them? How can we get rid of them? They called it playing whack-a-mole. And so they enacted this really stringent ban that is sometimes wrongly called a camping ban, but it's not just about camping. It's about being outside as a homeless person and just sleeping because there's no available shelter. The majority, led by Justice Gorsuch, joined by all of the other conservatives, reversed all of that Ninth Circuit precedent on Friday and held that it does not violate the Eighth Amendment to punish homeless people for being homeless. He claims that what they're really being punished for is sleeping outside, which is a kind of conduct that can be punished. And he pretends to be empathetic toward the unhoused, but in reality just leaves them at the whims of a majority that despises them and doesn't want them nearby or doesn't want to have to see or deal with them. I think, again, it's a really unfortunate decision. The effect that it will have immediately on homelessness won't be huge because all these decisions were tinkering around the edges, but it does strip homeless people of the one constitutional protection that they had from being targeted and fined and jailed, as the residents of Grants Pass were, just because they could not afford to have a roof over their heads.
And speaking of stare decisis, Justice Thomas has a concurrence in which he says that the court should reverse its 1962 decision in Robinson against California because he doesn't think it's cruel and unusual punishment to punish somebody for their status. That is, at least the majority understands you can't simply make it a crime to be homeless standing alone. Under Justice Thomas's version of things, you could make it a crime to be homeless. Even if you weren't asleep, just being homeless could be a crime. And, the kind of gratuitous cruelty of that coming from somebody who has an RV he can sleep in a Walmart parking lot if he doesn't have a place to put a roof over his head. Not everybody has an RV given to them by their friends.
Or a mega yacht, or, all the fun, good times on planes to go salmon fishing. I did think about you, Pam, as I read Justice Gorsuch's opinion, because there's so much Thurgood Marshall in there. And again, I think Mark's point is that Justice Gorsuch, in addition to being Western guy, really wants to be sensitive to the needs of the unhoused guy. And so there he is, pages and pages devoted to Justice Marshall. And it's such an interesting move to do what feels to me as well like gratuitous cruelty, and then to dress it up as I'm just like in a long line of people who are worried about civil rights.
Yeah, this reminds me so much of that amazing Sarah Vowell piece about people who compare themselves to Rosa Parks. And the idea that upholding a law that makes it a crime for homeless people to fall asleep puts you in league with Justice Marshall is just amazing. I still remember Justice Marshall's very powerful dissent in the bankruptcy case that you may remember, where the court said if you didn't have the money to pay the filing fee in bankruptcy court, you couldn't go bankrupt. And Justice Marshall said, be real, understand how people actually live out there in the world. What are homeless people supposed to do? Especially the ones who are homeless because of a disability or because of mental health issues that we're not treating or because of domestic violence. What are these people supposed to be doing? The court gives you no understanding of that at all.
Pam, can I ask you what you made of the majority's treatment of Robinson? You mentioned that Justice Thomas in his concurrence said the court should overturn Robinson. That was the case that said it was unconstitutional to punish people for their status rather than their conduct. It seems like Justice Gorsuch and his majority throws a lot of shade at it, but then doesn't officially overturn it, maybe because a few other justices like Barrett said at oral arguments, in fact, we don't want to go that far. But it seems like this is an example of what Justice Kagan was talking about in her dissent in the Chevron case, right? In this instance, the court just talks about how Robinson was weird and poorly reasoned and not built on the original meaning. In a few years, they come back and it seems like they've teed it up for reversal. And what flows from that, I don't know. But do you agree that it's at least pretty ominous how the majority treated that precedent?
Well, they're not super respectful of it, but even Robinson was narrowed pretty quickly by the Powell decision, which said, being drunk in public is not a status. Being an addict is a status. So Robinson is a case about being an addict as opposed to using drugs. Powell was a case about public drunkenness. And the court said, even if you can't help being drunk because you're an alcoholic, you can be prohibited from being drunk in public. And that might be true even if you have no place else to go. And so Robinson is not the most expansive of statuses. But if you get rid of Robinson, then what's to stop some jurisdiction from making it a crime to be a gay person in the jurisdiction or being somebody with particular other traits that are connected to your status?
And Mark, I think you are making the good point that this is the 1-2 punch where the court says we're going to all but hollow something out, but we're not going to overturn it. And then there's Clarence Thomas saying, "Oh, but I would," which is of a piece with the move to say in 5 years, "Oh my God, this was wholly discredited. We just let this husk limp along." So I think you're right that that's the play. We're going to link to a recent episode of What Next next in the show notes where Mary Harris spoke to a doctor who takes care of the unhoused community in Grants Pass. But I want to listen for 1 minute to Justice Sotomayor at oral argument in Grants Pass. She's talking to Thane Evangelos, counsel for the city. And let's just listen to her for 1 minute.
We think that it is harmful for people to be living in public spaces, on streets and in parks, whatever bedding materials, when humans are living in those conditions. We think that that's not compassionate and that there's
it's
no
not, but
dignity in that.
neither is providing them with nothing.
To
alleviate that situation.
This is a difficult policy question, Justice Sotomayor. It is.
Where do we put them if every city, every village, every town lacks compassion and passes a law identical to this? Where are they supposed to sleep? Are they supposed to kill themselves not sleeping?
And I think I want to say that Justice Sotomayor, there's lots of talk, she's the people's justice. She's constantly giving voice to those who have no power. But I just want to point out one of the things that I found incredibly striking in her dissent is she's not just talking about, the homeless as real people. She is also saying, I think, that people become homeless because of decisions taken by government. And she says this: people become homeless for many reasons, including some beyond their control. Stagnant wages and the lack of affordable housing can mean people are one unexpected medical bill away from being unable to pay rent. She says, individuals with disabilities, immigrants, veterans face policies that increase housing instability. Natural disasters play a role. She talks about people who've lost housing because of climate events such as extreme wildfires across the state, floods in coastal areas, heavy snowstorms, mental and physical health challenges. I almost read her dissent, tell me if I'm overreading it, as a sort of you dismantle the administrative state, you disable the government from dealing with climate and housing and mental health and health generally. You put a thumb on the scale against the regulatory state, you are going to have more of this, not less. And in some ways, it feels like this is almost a callback to the entire attack on the administrative state and government, and also the attack on efforts to do away with rich people who win all the time. And it's all bundled up in this kind of very, very deeply physicalized recitation of what it is to be homeless and why you get there.
Absolutely. I mean, these things are all connected with each other, right? If you don't have social services, think about the case that didn't go awry, the Moore case from a couple of weeks back, where they wanted to essentially prevent taxation on wealth, right? That was what the attempt was in that case. It failed. But this is an attack on the modern social welfare state across the board.
And it's no coincidence that Justice Sotomayor is the only justice who has a disability, right? Who understands what it means to have to try to deal with a physical issue while not having shelter. And she goes out of her way to cite a really wonderful brief by the Disability Rights Education and Defense Fund that talks about how only a tiny percentage of shelters in this country have accommodations for people with disabilities. Depending on how you count, less than 1% are accessible for wheelchair use. And so for many of these people, they just cannot stay in the few shelters that may or may not be available on any given day. And I'll just note, she mentions the climate crisis. She puts that at the foreground. She says some of these people are homeless because of the climate crisis hitting Oregon and creating wildfires and flooding and other anomalous weather events. Well, what is causing the climate crisis, right? It's emissions that the Supreme Court is preventing the government from limiting. So I absolutely agree. It's all woven together in a really masterful way. And I saw a lot of conservative commentators pouncing on Sotomayor saying, how dare she bring all of this stuff into this opinion that's not about law. It very much is about law when it's the majority that's enabling the dismantlement of all of the legal structures that are supposed to protect us, all of us, from those harms.
I mean, it's really as if Justice McScrooge has become the justice. Are there no workhouses for these people? We're going back to the 19th century as fast as the Supreme Court's feet will take us there.
Right. And Justice Gorsuch with a little nod to private charity and the place of religious private charity, because that's always the answer to all things.
Where you may not be able to get accommodations if you don't support that religion, subscribe to that religion, and attend religious services. Not so beneficent when you look at the rules that those private charities actually impose on people.
Let's talk about Fischer for a minute, because this, coupled together with the immunity case, becomes the sort of last gasp of will there be accountability for January 6th? And the court certainly narrowed the federal obstruction statute that had been used to charge at least 350 January 6th defendants. It's formed a piece of special counsel Jack Smith's indictment of Donald Trump in the election subversion case. Mark, the statutory question here is eye-crossingly complicated, but I'm going to ask you to unpack it for a minute, because this does seem at minimum like, if you read the obstruction statute the way the majority does, a pretty qualified win for the January 6th enthusiastic adjacent community.
So the court here is dealing with a statute that's been used to charge some 350 January 6 defendants, and it's an obstruction statute that was enacted in the wake of the Enron scandal. And it targets anyone who corruptly obstructs an official proceeding or attempts to do so. And that language seems pretty sweeping, and the Justice Department has interpreted it that way to secure convictions of many, many J6ers who interrupted the counting of electoral votes on that day, or who attempted to do so by invading the Capitol. What the Supreme Court did on Friday was significantly narrow the statute, but it did so in a way that I don't think will undermine a huge number of convictions or prosecutions. What the court did was say, look, before it talks about obstruction, this statute is talking about the crime of altering, destroying, mutilating, or concealing records, documents, or other objects with the intent to impair their integrity or availability. And so Roberts sort of grafts that first provision onto the second one, kind of Frankensteins them together, and says we have to look at this statute as one unified whole, even though these are really two separate provisions within the same law. There's the part about official records, and then there's the part about the official proceeding. But he says they're connected. So this law only permits conviction if the individual obstructed the official proceeding or attempted to, because they were trying to limit or impair or alter some kind of official object or item or paperwork or thing. And as Justice Jackson points out in a concurrence, that could mean the actual certificates of electoral votes here. So it's bad because it means that this guy's conviction has to be subject to review. And I think some other folks who were charged under the statute are going to have a second bite at the apple. But it's not, I think, a nightmare, because it does leave open the possibility that they could still be found guilty of trying to impair the counting of those electoral certificates. You just have to tie this more closely to the physical presence of the certificates and the defendant's alleged effort to make them unavailable. It's very technical. I'm a little baffled as to why Justice Jackson joined the majority, where Justice Barrett wrote the dissent, joined by Justices Sotomayor and Kagan. It kind of fractured the court, but I feel like it does take a middle ground that ultimately won't be fatal to a lot of these cases, setting Trump aside.
Pam, I am curious what you think. There's been a lot of efforts on Friday morning to say this is in no way a harbinger of what the court is thinking about Donald Trump. And there's in no way is this signaling that Donald Trump is off the hook. Do you read it as good news for Donald Trump, or do you read it as qualified, uncertain, we have no idea how this implicates Donald Trump?
Well, it's good news for Donald Trump in that, as Mark was saying, in order to keep those two counts in the 4-count indictment, the special counsel is going to have to tie much more closely together Donald Trump's activities and the attempt to impair the availability of various records. Now, I think that can be done because, among other things, he's saying use these certificates, not these certificates. And that is talking about a document and trying to impair the document's integrity or its availability. If you say don't count these, that seems to fall both within 1512C1, which is the initial provision, and within the 1512C2, otherwise obstruct, influence, or impede. So I don't think it's an off the hook for him. But what it does mean is it's going to take more time. There's going to have to be more time spent on this. And we already know that the Supreme Court has slow-walked the Donald Trump immunity to the point where there's not going to be a trial before the election.
We're taking a short break.
This episode is brought to you by Shopify. Whether you're selling a little or a lot, Shopify helps you do your thing, however you cha-ching. From the launch your online shop stage, all the way to the we just hit 1 million orders stage. No matter what stage you're in, Shopify's there to help you grow. Sign up for a $1 per month trial period at shopify.com/special offer, all lowercase. That's shopify.com/special offer.
Start your summer road trip at Midas and get up to $30 off your next repair service. Plus, get a free closer look vehicle check to make sure you're road trip ready. If you need brake service, an alignment check, or tune-up, hit up Midas for up to $30 off. For more details, request your appointment at Midas.com.
We're back with Mark Stern and Professor Pam Carlin of Stanford Law School. Do either of you want to opine on Mark's open question, which is why we see Justice Jackson throw in with the Chief Justice and why Justice Barrett throws in with liberals in this split?
I mean, Justice Jackson, it's kind of interesting, has come down on the government's side rather than the criminal defendant's side in several cases this year. This is not one of them. I mean, interestingly, she's been on both sides on criminal cases, which I think people might not have expected given her background as a federal defender.
First of all, I think that for Justice Barrett, this was an easy textual question, and I think she's absolutely right. You know, the majority's decision is really animated by this fear of, well, if we interpret the law this broadly, then what will happen next? And we heard that during oral arguments, right, with Justice Sam Alito, for instance, saying, but what about protesters at the Supreme Court? But what about climate protesters blocking the roads? Are you going to charge them under this statute? I read a lot of that.
What about anti-abortion protesters? We have to protect them.
Exactly. I read a lot of that fear as animating the Chief's opinion. I think that what Justice Jackson ended up doing was imposing not necessarily like a limit, but a perspective on the majority that will prove helpful for the government below. I think you'll see the government citing her concurrence a lot because she winds up saying, you know, yes, it can't just be obstruction. It has to tie back to some records, documents, or objects, but those could be related to the electoral votes themselves. And she goes out of her way to say, Mr. Fischer's conduct may well have involved the impairment of those things, and so he could still be tried and convicted on this particular charge. It just hasn't been proved to her satisfaction yet. So I feel like she's kind of splitting the baby here a little bit, and I don't hate that she did it, but I do think that if she wanted to take the textualist perspective and wanted to embrace her, you know, criminal defense background, Justice Barrett's dissent was right there, and it's a really persuasive dissent just on the plain text of the statute. You have to bring in these policy concerns, I think, in order to get where the majority lands.
I want to ask both of you a question that is sort of gnawing on me, and there's not much of me left ungnawed upon today, but there is one thing that is sitting funny with me, and that is not so very long ago, we talked about Fischer and the Trump immunity case as an opportunity to have a full-throated renunciation from the Chief Justice and the Supreme Court of the actions of January 6th. And not very long ago, I think a lot of us thought that whatever it is that the Supreme Court thinks about politics and Trump and policy and what's going on in democracy, blah, 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 at minimum, activities that happened across the street from the court that were really chillingly violent and lawless warranted some kind of statement from the court that this is too much and this is too far. And I read the Chief Justice's pretty bloodless recitation of what happened on January 6th as some kind of signal that the thing that I thought was determinative for most, if not all, of the justices on the court may just be determinative for me. What do you make of John Roberts seeming to be like, meh, as you say, Pam, more worried about old ladies handing out anti-abortion pamphlets than he is about January 6th?
They are avoiding talking about January 6th to the extent they can. I mean, there was no discussion of January 6th at all in Trump against Anderson. I mean, there was in the dissent, which came out pretty strongly in favor of saying, yeah, there was an insurrection. The only question is really whether Donald Trump should be disqualified as a result of it. I think, I just think they do not care.
I think it's interesting to bring up Anderson and look at the split in that case, which was 5-4 in part, with Barrett ultimately voting on the same side as the liberals, not to go as far as the majority did to shield Trump from getting disqualified, right? And Barrett didn't explain a lot of her reasoning, but if you look at her dissent in Fischer, I certainly sense more discomfort about January 6th from her dissent than I do from the Chief Justice's majority opinion. And I wonder if we can tie these two votes together, and that when January 6th comes to the court, perhaps Barrett is a little bit more icked out by the, violent attempted insurrection than her male colleagues to her right. I don't want to give her too much credit. This is just a hypothesis. We'll see what happens in the immunity case. But it does seem like the men are willing to just blaze past that and to whatever is necessary to help Trump and a number of J6 defendants. Barrett's not been there with them, not in Anderson about Trump, not here about some of the lower level January 6 defendants. So we'll see, but I don't sense that same agnosticism toward January 6th from Justice Barrett that I do from the guys.
I want to leave us all with this lingering question of all the ways that we are going to talk this weekend about Thursday night's presidential debate, which Pam blissfully didn't subject herself to. Mark and I did. It sort of misleads and I think misdirects the conversation about how government actually works. And then you get into which of these two guys is in fact setting policy for veterans and setting climate policy and immigration policy. And of course, that completely obscures the fact that the long march toward deregulation, doing away with meaningful voting rights, threats to the separation of powers really is the story, I think, much more so than the presidential debate of what happens to democracy when everybody's screaming at Jake Tapper. So, Mark, I wonder can you just help me reframe for people who are very, very, very consumed with the theater of the CNN presidential debates, the enormity of what is happening between jarcossy and, as Pam says, bump stocks and the decision on Friday in Loper Bright, and how that is in fact how government is done.
I think it's so illuminating to have had Loper Bright come down the morning after that debate, because Joe Biden did not perform well in that debate. And the reaction, especially on the left, was terror. A lot of fear about whether this guy could still serve as the chief executive of the United States. And I understand those concerns, obviously. And yet, I think that this pop vision of the president as essentially running the country is so far removed from how government actually works that at a certain point it is actively misleading us into putting too much stock in, say, the performance of a candidate on a debate stage. The government is vast. It is largely run by a bunch of agencies, which you probably haven't heard of, that are staffed with experts with deep knowledge and experience in a particular subject matter, with lawyers who affirmatively want to make government work, and with political appointees who, yes, may be ambitious, may have, their own partisan aims, but are in charge of a really important functioning part of government and are accountable to the president, who's accountable to the people. We never talk about them except when there's some ridiculous scandal by some secretary and he or she has to resign. And yet they are the ones who are interpreting and executing the laws day in and day out. They are the ones approving or rejecting rejecting applications for new drugs. They are the ones targeting and limiting pollution from some dirty factory in West Virginia that's creating a cancer cluster in a majority Black community. They are the ones who are making sure that we are given the full scope of protections that Congress aimed to give us when enacting broadly worded laws. That's how government works. And all of that is anathema to the Republican Party and Donald Trump. Donald Trump's key goal was dismantlement of the administrative state. Steve Bannon said it himself, and it's a fundamental part of Project 2025. They want to stop government from working because everything I just described, it's bad for billionaires. It's bad for polluters. It's bad for industry that wants to get away with dumping pollution into our waters, with selling drugs that aren't safe, with making a ton of money and taking those ill-gotten gains and sheltering them from taxation, right? And we are still talking about Biden stuttering on a debate stage instead of how each of these men would staff and run the sprawling government that they would ostensibly be at the head of. If we had a healthier conversation about this, we would be talking so much more about Loper Bright than we would about the debate on Thursday night. But because most Americans, I fear, still fundamentally misunderstand how the wheels of government truly turn, we're obsessing about Biden's sore throat and not talking about one of the biggest power grabs that the judiciary has ever undertaken.
And just to highlight something that Mark said, what Mark is actually saying in a way is whichever candidate wins this election, the Supreme Court is going to be there to dismantle the regulatory state. And that's what the real story of this is, which is underneath, even if a Democratic president, even if a vigorous Democratic president, even if a 39-year-old Democratic president were elected, the Supreme Court might be there to kneecap attempts to deal with climate change, attempts to deal with securities fraud and frauds that affect people's pension plans, with attempts to deal with medical emergencies and EMTALA. The Supreme Court can dismantle all of that without regard to who's in the White House. And that's what the big story of this last week at the Supreme Court has been.
Professor Pam Carlin is co-director of Stanford Law School's Supreme Court Litigation Clinic, and she has served, among other places, as assistant counsel and cooperating attorney for the NAACP Legal Defense Fund, and twice as a deputy assistant attorney general in the Civil Rights Division at the Department of Justice. And Mark Joseph Stern covers the courts, the law, elections, the end of democracy, and thankfully not a president who has a sore throat. That is not your beat, Mark. Thank God. Thank you both for being here. I guess we are going to put on our crash helmets and wait for whatever comes on Monday and the end of the term. But until then, I am so grateful for both of your big brains and your voices. Thanks for being here.
There's no one else I'd rather sit Shiva with, Dahlia.
Yeah, some sable, some sturgeon, maybe a little cream cheese.
And that is a wrap for this episode of Amicus. Thank you so much for listening in, and thank you so much for your letters and your questions. You can keep in touch at amicus@slate.com, or you can find us at facebook.com/Amicus podcast. Sarah Birmingham is Amicus's senior producer. Our producer is Patrick Fort. Alicia Montgomery is vice president of audio at Slate. Susan Matthews is Slate's executive editor. And Ben Richmond is our senior director of operations. We'll be back with another episode of Amicus next week, probably something on Monday for our Plus members. Please join if you don't want to miss out, slate.com/Amicus Plus, or try free at the top of our show page if you're listening in Apple Podcasts. Until then, let's all hang on in there.